That matter's ready, Your Honor.
And I didn't, is Mr. Goodday here? Ah, there he's coming in. Let's make sure he's coming in here. All right, so this was a motion to compel. Where are we at on that?
We've received no response, which we didn't expect to. I believe that Mr. Gade is working with his client. I'm not sure about that. I'd asked to sign the first order compelling. Your Honor, can make the decision whether or not fees are appropriate, given that Mr. Gade is appointed counsel for Mr. Radcliffe. But I'd ask that we have a review set in 2 weeks, and hopefully we'll have the discovery by then. But I would ask that the first order compelling be signed.
Excuse me, I'm Mr. Radcliffe. I've been trying to contact Good Day and everything, but I haven't been able to fill out the papers that were asked me to fill out. So I haven't seen them at all or anything. Like, I just talked to Far last night, and she told me to talk to the judge about maybe getting a new attorney or something, or maybe do something about this.
All right, well, hold on a second. So let me talk to your attorney for a second. Mr. Goodday, did you receive the motion on this one?
Yes, Your Honor, and I did receive a call from my client, and then I was understood that he was in treatment for a while, so we haven't been able to connect, but I would like some more time if I could to speak with him.
So I guess my question is a request to have discovery completed and returned by July 16th, which is 2 weeks from today. Is that sufficient time to have that accomplished?
Yes, Your Honor.
Yeah.
All right, let me see here just a second. I don't know.
And just so Your Honor's aware, that order proposed does have that attorney fees language in it that is standard, but I understand him being court appointed, Your Honor. I defer to the court on whether you scratch that or not.
Yeah, and I don't have an action. There's an order filed. I don't have a bench order that I can see here. I'm looking.
And we can shoot it to you again. It was provided to the court about 3 weeks ago, so with the original motion, so it might just be flying around the court. I can have my legal assistant deliver another one.
Okay. I think at this time, given the circumstances of the Mr. Goodday being appointed counsel, I will decline on the fees at this point. That may be something I'll reconsider at a review. But at this time, I'll set a review in 2 weeks on the 16th from today. Assuming all of the discovery has been received, that can be stricken. If it's not received, I'll take up the request about attorney's fees at that time. So, Mr. Radcliffe, you and Mr. Goodday need to make sure you connect up in some fashion, get the documents signed and back to Ms. Winkles. We'll take a look at it in 2 weeks.
Thank you, Your Honor.
All right, thank you.
Thank you.
All right, you're welcome. So, Ms. Winkles, if you can, and that can come over via email, is fine. Let's see here. I've got.
Amy Powers here for the petitioners. We filed a motion for default against Ms. Barnes, the mother, and also sent over proposed final orders. The GAL, Amy Turnbull, has signed off on the final order, and so has Tom Lee, attorney for the child.
Okay, do you have those orders? All right. Just 1 second here.
Your Honor, Attorney Dino Glick here on behalf of the mother.
These might be duplicate orders. I don't know.
All right, so Mr. Gojak, you're representing the minor, correct?
The mother, Your Honor.
The mother has appeared at hearings, and Mr. Gojak was appointed at the end of March. We've had several hearings since then, but Ms. Barnes has not filed any response.
So, Your Honor, my client has stated a couple of times on record that she consents to the guardianship. I've had minimal contact with her between the hearings. It's just been it's just not been the best of contact. So at this time, I would ask the court to allow me to withdraw as counsel. I don't believe there's anything more I can do without contact, and She has indicated on a couple occasions that on record she's consented, but there's been a couple occasions where she's said that she was thinking of objecting to it. So I don't have any further information than that for the court.
All right. So based on based on that information, we'll allow withdrawal of Mr. Gojak. I assume you're not objecting to an entry of a default at this time, given the historical representations?
Unfortunately, I can't take a position either way, Your Honor.
Okay. So based on no response, she has appeared requesting counsel. Obviously, you were appointed. We've not, and she has consented at least at some level. I will enter a default order today. And again, Mr. Gojek, if you want to file withdrawal effective today, I assume we have some fees that we will need to reimburse you on.
Yes, Your Honor, I can file a motion for compensation. Does Your Honor want me to file a notice of withdrawal or an order?
Probably just an order along with your request for fees. We can put it all in one order if you want.
Okay, I will do that, Your Honor. Thank you very much.
Melissa Menzel, Your Honor.
Good afternoon. And this was on, I believe, just kind of as a placeholder.
Yes, unfortunately, Your Honor, the mother has gone missing in action. Myself and the father has come to an agreement. The mother has chosen to block all contact with her children, all 4 of her children. And Mr. Black is unable to participate today. He is actually tending to the needs of his other minor child who has recently been hospitalized due to some suicidal tendencies because of some unfortunate circumstances with the mother. I have hired a private investigator to be able to locate mother. We do believe that she is now located out of Seaside, Oregon. She moved and she changed her contact information. She blocked her kids on all social media forums, as well as she changed jobs. So at this time, we would just like to ask for you to assist us by extending out the order that we currently have, so we can continue forward with our agreement and attempting to work through the courts of California, as well as tending to the minor child, Bailey, who is currently in my care, so she can seek the mental health services that she needs, as well as participate for educational purposes.
I guess, has anything been filed in California at this point?
We did. What happened is the father came to an agreement. There was a restraining order actually placed against the father when we arrived back in California by the minor child. And so we had to go through the process of that. And then we were starting the guardianship. The father came to an agreement. So at this time, it is not currently on the court document. He's asking that we do something with the mother's agreement as well, just as a joinder of their family case. And as of right now, his main focus is his 14-year-old son, who has been going through some unfortunate circumstances. But we are in the process of seeking mother's whereabouts.
Have there been any orders at all entered in the California case?
No, there has not, Your Honor. There has been notarized documents done between myself and the father. Unfortunately, without a signature from mother, they're not considered valid yet. I'm actually in the state of Oregon. I've had to come here to hire the private investigator to make sure that they will be able to meet the needs that are necessary in regards to searching for her location.
All right. Well, it's a very unusual case. What I'll do, is just simply as an accommodation at this point. Mother's not here objecting. I know father has expressed on the record being in an agreement with
Yes.
continuing this process till that can be resolved. I'll assume at this point that Washington is still operating under emergency jurisdiction.
Correct.
Based on the child's presence here.
Correct. We are actually located in Washington at this time and staying in Washington while pursuing the dealings with the private investigator.
So given the circumstances, I think what I'm going to do, let's see here.
Could we possibly consider calendaring it until, I mean, I don't even know at this point, like maybe the end of August? That would give the father the opportunity for things to be able, so he could seek the services necessary for his son. Hopefully we'll be able to be on a court calendar in California by that time. Mother will have been located and Bailey can continue with her medical services that are necessary, as well as, you know, school starts. She's participating in summer school right now. So
Well, what I'm going to do, I'm not going to go quite that far. I'm going to review it at the end of July on the 30th. That's
okay.
about 4 weeks out.
Thank you, Your Honor.
My suggestion would be is to see if you are able to get some sort of temporary order, even an emergency temporary order in California, since based on the UCCJEA conference that we have had, that is where jurisdiction or continuing jurisdiction over the minor is.
Which is what I was attempting to do when I returned home to California. While Bailey was going through the process of her restraining order, both in here and transferring to California, I did attempt to start that process, and father had decided that he wanted to come to an agreement. And so we were attempting to do that and was in belief that mother could possibly be in agreement, but she's cut all contact.
Okay. Well, again, I've extended this out through the 30th of July. That's on my docket at 10:30.
Thank you, Your Honor.
That's the right thing, and we'll take a look at that point. Hopefully we can get this moving in the right direction in the other court.
Thank you.
All right, you're welcome. And let's see here. Ms. Farr, good morning.
Good morning.
Where are we at on this case?
So both parents have recently been served. I haven't seen the proof of service on either one yet. The documents are in the process of being filed. The petitioner didn't keep copies. I did see the service from the sheriff's office on the mother, but I didn't see anything on the father, but she tells me that it was completed. So we have the most recent order appointing emergency guardian about a month ago. So I think we just need to extend that out to give the parents time to respond before we move forward, with other options.
Okay. This is just working from my memory. I was out last week, so I'm kind of digging a little bit here. This was the case where we have a third-party custody case, but we're moving the kids to some other people, which is the purpose of the whole case. Is that
right? We had the issue with the motion to convert and all that. That's the case, but I think that's all been resolved the way that the court wanted to handle those documents. That portion of it, the conversion. So that was the grandmother, the father's mother, who had the NPC, and she's in agreement. She's been served with everything. She's in agreement with the guardians being appointed.
Okay, so the last order we did, which was May 28th, actually appointed
The Foxes.
Yeah, appointed the Foxes under the emergency order. So we're just simply asking for another 60 days on that. Is that where we're at?
That order actually was only 30 days, but yes, if we could go another 60, that should resolve the time for the parents to respond, and then the Foxes to decide how they want to move forward.
All right, and I don't think I have one of those orders in front of me here. I'm gonna have to go grab one of those to write it when we're done here. So I will enter another order extending that out from today's date for 2 months, basically. let's see here. It's going to put us.
And mother is actually incarcerated in Lewis County right now.
Why don't we put that on for August 27th? That's a Tuesday. That's actually 50s. It's
Your Honor, could we actually put it on for the 20th instead?
we could, sure.
Okay.
So put it on for August 20th. So I'll extend the order out till the August. Well, let me do this. I'll extend the order to the 27th, but we can review it on the 20th.
Okay.
Give us a little cushion there.
Thank you.
So 10:30 on the 20th for review. I'll extend the orders to expire on the 27th of August. And so I'll simply duplicate the order that was entered on May 28th with those dates added to it. Okay.
Thank you, Your Honor.
Thank you.
And then we'll be back on August 20th for a review to see where we're at. All right, any other matters? Ms. Corey, we were talking about the Fowler matter. I understand you need some additional time. CQ are muted.
Terribly sorry about logging on
Right.
late. Yes, the amount of records that I received I terribly underestimated the length of time it would take me to review those. I apologize for that. I really just need a few more days.
All right. Well, at least initially we were going to set it over a week to is that sufficient time at this point?
That is.
Okay.
And Your Honor, because Ms. Corey was absent for our discussion on the discoverable documents, if the court could make Ms. Corey aware of what you believe on them.
Well, apparently you've got medical records. I would think not having a motion or any law in front of me that if you're going to base your decision on those, and then counsel would be entitled to look at those. I don't know how the HIPAA interacts with what your ability to release those are. Mr. Fowler's not in favor of that release at this point, so it may be something that requires a motion, but I mean, maybe you can advise us as to your understanding of that ruling as it applies to JL records.
I don't know of any time a JAL has released such records to an attorney. And on each disclosure records that they send out to me, there's a statement, and the one that is on Mr. Fowler's records that I recently received. May I read that to the court?
Well, you're talking about the stamp that's been put on there?
No, it has to do with the Code 42 of Federal Regulations, CFR, in Part 2. And it specifically says the rules prohibit you from making any further disclosure of this information unless further disclosure is expressly permitted by the written consent of the person to whom it pertains, or as otherwise permitted by 42 CFR Part 2. And I did go to that regulation, and well, I'm not an attorney, so it wasn't terribly clear to me, but that, I believe, is the regulation that applies here.
So if that's for substance treatment records, I'm familiar with that statute. That would require some sort of a motion if it's not an agreed release. So there's a process.
Thank you for thank you for the clarification, Your Honor. Thank you, Ms. Corey.
All right, so we'll set it over a week for review on the report and go from there. So that'll be to the 9th of July at 1 o'clock.
Thank you.
Thank you, Your Honor.
You're welcome.
Yeah, thank you, Your Honor.
And Mr. Agnostos, you're here on the Roberts matter.
That's correct, Your Honor.
I have a couple of questions. Is this Mr. Roberts?
It is.
Okay. So I guess I was a little concerned on the, didn't know he was going to be here, so apparently you received the documents. This looks like it was served via email, which was, I don't know if you have an agreement to do that, but he's here. So, so in looking at it, this is probably going to need to be set for more lengthy than a docket matter, I'm guessing, because I tried to go through the information. And this is a case that I heard and did a decision on about a year ago.
Correct.
And I haven't had an opportunity to really go back and review through that and those notes from that.
Right.
What I could do is see if I can get court administration to log in and we find a time we could actually do that.
Sure. Mr. If I could, Your Honor,
Sure.
just briefly, Mr. Roberts brought in $750,
Okay.
and which is the amount he would owe my client for June, but he also owes her the from our point of view, the house payment. But I had a conversation with him when he came in and dropped that check off, and I think he agrees with the numbers, with the exception of attorney's fees. He doesn't want to pay my attorney's fees. And what I'm looking for is out of today's hearing, is what I was hoping for at least, was to have Mr. Roberts, because Mr. Roberts wants to retire. That's part of the conversation we had. And you know, you can speak with Mr. Roberts, but he has a deferred comp part of his pension. And he and I talked about him withdrawing that and paying the amount, whatever the court ultimately sets. We've asked for just under 50,000. And then after that, he's looking at retiring, and we need a wage assignment for whatever the amount of spousal support. We think it's 2,200, and he wants to. I mean, I think so. The court order is, but I think we're down to just some very few narrow issues. So I don't know that we need to set up for a hearing, but if that's what your court, what John wants to do, I mean, yeah.
Well, the specific, I guess the specific provision was going to be reviewing both maintenance and property division once the house sold.
Right.
And I mean, I've got a lot of numbers here, and I don't know where the maintenance is going to end up once that. So without at least some time to review through that and look at that, not really in a position to make a ruling on it. I mean, if you all agree on something, that's one thing. But
well, we don't.
okay.
I mean, we have narrowed down from my point of view, I thought, the issues, but.
All right. Well, a couple things. I mean, anything that you both agree on, or you all agree on, you certainly can you can do that, and then subject to a final decision by the court, which I'm not going to undo anything you've all agreed to.
Right.
That's not a problem. Mike,
so if I may kind of rephrase what you're saying, Your Honor, my understanding is we're going to set this for a hearing with regards to the amount of spousal support going forward, and the property issues unless they're resolved.
correct. Because what I'm looking at, I'm just looking at the provision in the decree. It said once the home sells, a final net amount, which would be the property division, is
Right.
any final net amount of the house sale is determined, less sales cost, court determined, shall review maintenance and property division. And then there's some questions about wife and disability finding, a modification. So there's a lot of bits there that I, again, without going back and let me see here. I don't know what those numbers are going to look like. I mean, if you all come to an agreement on something, that's fine with me. But if I need to make a decision, I want to make sure I have the numbers in front of me and understand it.
Right. Okay. So we need to set that for a hearing on universal.
Well,
Or can we do that today with you, or?
you can sit tight for just a second. I'm going to see if
Because, I mean, this needs to be heard by you, I believe.
Well, I have to hear it. Yeah, that's the question. My biggest problem is I got a 2-week trial starting on Monday, which will be, for the next 2 weeks are pretty well tied up, but let me see if I can get her. And this is a case I heard, and I need to hear kind of a post decree, some discussions about property division and possible attorney fees, that sort of thing.
Okay.
I'm guessing I could probably fit it into an hour slot, I would think.
I would think.
If I've got all the information. And I know I'm tied up the next 2 weeks. Do you have any spot you could find me an hour somewhere we could poke this in?
Let me look at the schedule. You have another special set on the 23rd and 24th. Is this something that could go on the universal trial assignment docket? So we can look further out? Or does it need to be set now?
It's got some urgency because we've got some ongoing payments that need to be addressed.
Okay. So
What?
could we do Monday, July 22nd at 9? So that would be before your protection order docket?
That would work for me. Yeah, I mean, that won't be a problem fitting it in there.
If the parties are available, that would probably be work the best. That would be by Zoom.
Unfortunately, I have a mandatory settlement conference
What
on Monday, the 22nd.
would you folks be available Friday? This like the 5th?
The 5th?
The 5th of July, yeah, the day after.
Yeah, I can make myself available. I was marked out for the 5th, but
How can you do
is the
that?
court open on the 5th?
We are open and I have a trial in the morning, but that morning that's set with that term, that's really a motion hearing docket. So I'm thinking if I went to the afternoon, I
Set
don't
that
know what
whole
else.
day aside just because we didn't know how long it was going to take, but I'm sure it would fit in the afternoon somewhere. We could do it by Zoom, so parties didn't have to come.
Yeah, we could certainly do that. Would work. Do you want to try for one? I mean, I could do it Friday at 1:30 if that would work for everybody.
That's fine, with the exception of my client, and I'm not sure about Mr. Roberts would like it to be in person. So we could.
I'm fine with that. Yeah, we can do it in person.
Yeah, we can do it in person.
Just trying to, if it's more convenient for you, you can appear virtually, but yeah, in person's easier for me as well. So let's shoot it for Friday the 5th at 1:30.
Okay.
I know I've got a detention docket at 11:30 and sometimes those run a little long, so that'll give me a little cushion there.
Perfect.
But the trial will not go all day. It's motion hearings.
Okay.
So.
All right, I'll put that on our calendar.
Okay, so Friday, July 5th at 1:30. If you've got anything you want to file for me to look at, if you could send that directly to court administration, because it won't make it into the file that quickly.
Okay.
So, and I think I've got all your motions. So, Mr. Roberts, if you've got anything you want me to look at, any paperwork, make sure you get a copy to Mr. Anagnostou. And then when you come to the clerk's office, tell them it goes to court administration for this Friday. And that'll give me a chance to look at it beforehand. Okay, 1:30 on the 5th.
All right, thank you.
As a friend of the court, I was the attorney of record for Mr. Roberts at that trial. Would it be helpful for the court for my office to provide new exhibits? I know that the court has destroyed them. I don't know if you needed that for my office.
I don't know that there's a bunch of documents that have been filed with relation to this issue, so I don't know that I have any specific need. You may want to talk with Mr. Roberts, see if there's something that he thinks he'd like me to look at. Happy to.
Okay, great. Thank you.
Okay, so Mr. Roberts, you may want to give Ms. Gilmore a call and you can chat with her. Okay, thank you. Thank you, Jalen. Okay. So we've got the Walker and Walker matter.
Amy Powers here for Mr. Walker. Mr. Walker is present in my office.
And I see Ms. Boaglio is present.
Hello.
Good afternoon. Okay, so you got a fair amount of documentation, and I did see a response from Ms. Boaglio. So I guess let me just make sure I understand. Ms. Boaglio, are you asking for additional time, or you want to proceed today?
I am okay with proceeding, but I do have issues with the child support calculator as it was submitted. So what I was requesting is if the court could enter a different amount based on, Your Honor was requesting full disclosure for income, which Jonathan didn't provide. And from my understanding, that means typically the court would determine based on past income, which I provided for the court.
All right, Ms. Powers?
Thank you, Your Honor. We're here today on the issue of a child support modification. The court first heard argument on this on June 18th and set it over to today, asking my client to provide additional information to the court. We filed an updated financial declaration, which disclosed the remaining resources that Mr. Walker has in his home. You may have noticed that the financial declaration that we initially filed had higher expenses than the updated financial declaration. And the difference between those two declarations is that Mr. Walker is receiving food stamps and help with clothes and diapers and household supplies. In his initial declaration, he had included the amount that those things cost. In the updated declaration, we took those expenses out because they're covered by the food stamps and community partners who provide those resources for his family. So that's the difference between the two declarations. We also provided his 2023 tax returns, documentation of his food benefits, his Lower Columbia application. He discloses in section 10 of his amended financial declaration that he is receiving food stamps, SSI for one of his children, and child support for his stepkids in the home. We also filed a declaration from his relative, letting the court know that Mr. Walker and his wife have borrowed $10,500 from him, a total of $10,500. The relative explains that that's been paid out in different chunks based on needs, but it has been a total of $10,500 and is expected to be repaid. Mr. Walker also explains in section 10 of the amended financial declaration that they rely on their tax return to help pay bills as the year progresses. So I believe that we have provided full disclosure of Mr. Walker's financial situation. We have agreed with the court that he's currently we have agreed with Ms. Boaglio that he is currently underemployed. The RCW 2619-071 indicates when a parent's underemployed, we impute income, and it sets the priorities for imputing. First, you impute at current rate of pay. Second, you impute at full-time earnings at historical rate of pay. We filed Mr. Walker's pay stubs on September 8th, 2023, showing that he was earning $16.50 an hour when he was last fully employed at Lowe's. We've also filed his declaration that shows his work history, that he had been making more money when he was working significant overtime. That job ended in November 2021. Ms. Boaglio has just filed under sealed financials information showing that Mr. Walker was earning $20.80 an hour at that job in 2019. As Mr. Walker has supplied for the court, he hasn't worked that job since 2021. After that job ended, he worked at a nail salon for 5 months, and then he worked full-time at Lowe's, earning $16.50 an hour. We asked the court to impute him at $16.50 an hour, 35 hours per week. We believe that that is accurately reflective of what he is capable of earning in a full-time position. I went ahead and did the calculations, and at $16.50 an hour, 35 hours per week, that lands at about a gross of 30,000. Alternatively, if the court adopted the 20.80 an hour that he was earning in 2019 at 35 hours a week, that's a gross of about 38,000 per year. So it's not a significant difference between the two, but that is what the difference is in terms of gross incomes. So we would submit that it should be imputed at $16.50 an hour, 35 hours per week. I believe that was the only remaining concern that the court had from our hearing on June 18th. Just as a quick recap, we've submitted proposed worksheets. They have the mother at $20.35 an hour, 35 hours per week, and then the father at $16.50, 35 hours per week. That results in a standard calculation of $422.60. We're asking for a whole family deviation for Mr. Walker's 3 other children. That results in a transfer payment of $216. And then we're asking in September 2024 that it automatically adjust to a whole family deviation with 5 children, since his twins are due in August. And that would drop the transfer payment to $167 a month. Mr. Walker filed his own motion to adjust child support on September 8th, 2023. He filed a financial declaration, financial information with that. Because he filed it at that time, we are asking for a start date of October 2023. And we ask that child support be ordered proportionally between the parties, and that a specific amount of child support not be included in the worksheets, since that amount can change month to month. And with the child starting kindergarten in the fall, that would certainly be a time to change, but instead each party should be responsible for their proportional share. Ms. Boaglio has requested that child support start being paid through the child support registry. We have no objection to that. So that is our position.
Right. I guess I'm confused. I don't see a worksheet.
It was the worksheets we initially filed. Let me see, I can tell you. They were filed May 30th, 2024.
And Your Honor, I also would like to have an opportunity to respond to the comments.
I will. I'm just trying to understand the comments, and then I'll be happy to listen to that. So that's the one that would show 422.
That's the standard calculation, but we're asking for a whole family deviation for the 3 additional kids. And if you look at the end of that worksheet, I've attached the whole family deviation that shows when we have just the 3 additional kids, the transfer payment's $215.69, and when we have the 5 additional kids, it's $166.78.
Just a second here. Ms. Boaglio, you had some comments.
Yes. So we have started this process originally because I had filed for a motion to establish cause for contempt for the reduced payments, which Your Honor had stated that since we had made an agreement about the child support payments in the past, that meant he was not in contempt, but that we had never made an agreement about the schooling fees for Caleb. So those were also on the table, and Your Honor had said that he would be in contempt for that when we were in court last. He has not paid the schooling fees to me or made any effort to make that right. So that was just the first issue that kind of started this process. In regards to some of the comments by Ms. Powers, so she agrees that he is underemployed, and based on what I read in imputation of income, It says that the court would not impute income to a parent who is gainfully employed on full-time basis unless the court finds the parent is voluntarily underemployed or unemployed, to reduce the parent's child support obligation, and she agrees he's voluntarily underemployed at this point. So I'm just asking that the court would impute at his rate of pay that he's capable of earning, which would be based on income that I submitted for the court. Also, I do not feel that there was full disclosure about his income currently based on some of the statements by the family in the agreement that was submitted, said that they also loan or give other amounts of support based on what's needed at the time. And when you add up the amounts, it's not enough to cover his expenses, yet those expenses are being paid. So it just seems to me like there's some things that are being intentionally hidden as far as the full disclosure of income. So I would ask that based on that he would not be given the diversion.
May I reply briefly, Your Honor?
Sure. Go ahead.
As indicated earlier, it wasn't the contempt that led to the adjustment of child support. Mr. Walker filed the motion for adjustment on his own in September. He didn't understand the process to docket the hearing. The contempt came later on. The parties have provided information to the court that they've been negotiating between themselves, and that's what led to the motion to adjust child support back in September. Ms. Boaglio did submit some proof of Mr. Walker's income, and in 2019 he had grossed about $53,000 based on the information she submitted. In Mr. Walker's declarations, he explains to the court he was working very significant overtime, an unsustainable amount of overtime during that time period, which is why his gross was as high as it was. The same paperwork that Ms. Boaglio submitted with the $53,000 shows that his hourly rate was only $20.80. I think the real question for the court is, definitely he needs to be imputed, but what's the right imputation? We'd argue that it's $16.50 an hour. If the court does not go with the $16.50, then we'd ask that he be put at $20.80 an hour, 35 hours per week, based on the evidence before the court. Lastly, in terms of full financial disclosure, the amended financial declaration of Mr. Walker shows that his monthly expenses are $3,000. He discloses in there that he receives $375 a month for child support for his stepchildren, $943 for SSI. Plus, he is also working and grossing about $958 a month from working. That gets him fairly close to $3,000, not quite to $3,000, but close. And then he discloses the loan from family. I believe that we have provided full disclosure of his situation. He is almost making it, but not quite making it. He's disclosed the food stamps. He's disclosed the assistance from the community, Lower Columbia, and we believe we have fully disclosed everything, and we ask the court to grant a child support adjustment.
Okay, and he filed this in September?
He did. He filed the motion on September 8th, 2023.
And Your Honor, when he filed that motion, he was also requesting to have 50% of custody, which I did not agree to. So I did not agree to the full order. So I chose not to. I was allowed to respond to that, and I said that I did not agree to the changes.
They filed a petition to modify as well as a motion to adjust, looks like.
And at that time, they were also saying a lot of things about me that were untrue to the court. So I was feeling uncomfortable with agreeing to the majority of what was in there.
I guess
There was also oh, sorry.
I guess the concern I have is I've got two declarations filed under penalty of perjury from Mr. Walker, one with an expenses of $6,000 and then one with expenses around $3,000. And I guess I'm not really clear which is which. He indicated initially he had no income, and then I've got the one now saying that he has income.
You look at page 2 of his original financial declaration, he did disclose the same income in terms of his wages. He just had not included the SSI for the child support for his stepkids, or the food stamps. So the difference between the financial declaration he filed on June 11th and the amended on June 27th is that he has disclosed those additional resources, which were not income, but are resources into the household. And then we subtracted out the cost of the food stamps, of the groceries and household, because that's covered by the food stamps. And we took out the cost of diapers and clothing because that's covered by the organizations that are providing diaper and wipe and clothing help for the family. So those are the differences between the two. When we had submitted the first one, I had not realized that had been double included.
Well, I mean, regardless of how it's getting paid for, his expenses, I mean, he's listed 3,400 in food and household expenses in one and 350 in the other.
The difference is because the cost is the 3,400. It's just that the majority of that's covered by the food stamps and help he's getting. So the 350 is what he's paying out of pocket. That's my understanding.
All right. Well, I mean, neither of these declarations are accurate then, because they don't include I mean, the income from the food stamps or whatever that's going against the actual expenses should be included in his income.
He has disclosed that under section 5 or paragraph 10 on page 5 of the amended declaration, of the amended financial declaration.
Okay. So then if I'm understanding correctly, expenses are 6732, of which 3,052 he's coming up with from his income and gifts, etc. And then there's another 3,000-ish that's coming through these other resources. Yeah,
About 2,000 in the food stamps and WIC benefits, the 941 in SSI, the 375 in child support for the stepkids.
Where is that included in?
That's on page 3 of the amended financial declaration. You can also see it under the sealed financial on the food program. It's the first page of the sealed financial that was filed on June 27th, that shows the child support per child and the SSI for Liam.
So there was a few other things that are incorrect in what he's claiming. The value of his car is incorrect.
And I would object, and that does not.
That doesn't have any impact on the decision as far as monthly support at this level. I mean, it's information that's there, but I'm not coming up, when I look at your doc, I mean, I'm not coming up with the same numbers. So
there's also an error in the calculation where my income is listed and then it says federal income tax, or the amount of tax every month, instead of it being subtracted from my income, it was added into the calculator so that my ending income looks like it would be more. So if you were to pull up the child support calculator and look at the tax amount, you'll see that it's added rather than subtracted to my income.
And I can explain that difference. My child support calculator program calculates in the tax benefit based on which parent is getting the exemption. Ms. Boaglio gets the tax exemption, and as a result, it did result in some credit towards her tax-wise.
Is that based off of a tax return?
That was based off of the current child support order that gives Ms. Boaglio the exemption.
No, I mean the number that you've calculated, the 350, 375 being added back in.
That my program just did that on its own.
Okay. Well, I honestly, I cannot determine what his income and expenses are based on the declaration that's been filed, because it doesn't, my numbers don't come up the same as the numbers that are shown on your declaration. I don't know why. I looked at this prior to court and I was trying to follow through the explanations. And does his spouse have any income?
She does not at this point. She's having a medical issue and is pregnant with twins and unable to work at this time. The second set of twins are supposed to be born this summer. Her plan is to return to work as soon as she's able. That's a big part of how we've ended up in this situation. They've had two sets of twins close together, and his wife has had a lot of health issues as a result of both the first pregnancy and this current pregnancy. He needed to take more time off, which led to the end of his job at Lowe's. So we're kind of in this crisis state until we get through this second birth, get things settled, and both people can return to work in a regular manner.
Your Honor, this has been an ongoing thing since Nash, or Jonathan, since he and Hal were married. And it started with him taking 3 months off of work to go to Thailand, which I imagine any job would not really be willing to accommodate. And it's been a lot of different reasons over the years that I've heard. I'm usually very graceful, but it feels like it's just an ongoing thing.
All right. What I'm going to do on this, I'm going to take this under advisement. I'm going to go try and rerun these numbers again and make my calculations at least match up as best I can. And I'll get you a decision via email probably this afternoon.
Thank you.
And ma'am, I believe we do have your email address. I think there was an agreement to do.
We have a GAL review hearing already set for July 30th. Can we add presentation for that same day?
That's fine. I'm just looking for Ms. Boaglio's. I believe I have that in email. I do. There it is. Okay.
I think you do. Yeah.
Okay. So, and what was the date on that up top of you?
July 30th. And I'll draft these orders, and I will also draft the contempt order from the last hearing as well. And we can just enter it all at the same time as the GAL review hearing.
All right. So, and I'm going to do my best to have that out for you today. I've got to go back and do some recalculating because my numbers are not coming up the same.
Okay. Thank you.
Okay. So July 30th, we'll have presentation as well as GAL review.
Thanks.
Okay.
Your Honor, what would
Yes,
what would you be wanting from me for presentation for July 30th? I just want to understand. I'm not always familiar with the court lingo.
Well, Ms. Powers will send you per proposal for what the written orders should look like. If you disagree with those, you would file something in writing that says what parts of those orders you disagree with. And it's not an issue of whether you agree with what my decision is whether the orders that she prepares matches up with the email decision that you'll get today.
Okay.
Okay?
Does that mean, oh, sorry, I'm just,
go ahead.
So as far as the amount to be entered for his income, so then she would choose that based on what she wants it to be, and then I would respond.
I will give you, I'm going to make a decision about the number.
Oh, okay. Thank you.
The start date. You'll get a decision today about all these issues, and then she'll put that into an order. And what you would be objecting if what her orders doesn't say what my decision says.
I see. Okay.
That makes sense?
Thank you. That helps a lot. Yes, it does.
Okay.
Thank you.
No problem. All right.
Very
This one
good.
is a little confusing as well.
Yes, I was equally confused, but I don't believe we have an active motion from either party. I think that there was some confusion or I guess leniency when we were before the court on the pro se docket when the parties didn't have attorneys. As we stand before the court, I think the ruling from Judge Warning is that everything was kind of status quo or stayed until we had the GAL report. I know, and I haven't received that yet. I don't know where we're at in the process of that. I am a little apprehensive about moving forward regarding visitation and support without that report. But obviously on the other side, my client would like visitation and potentially to adopt our parenting plan if the court is willing to entertain these arguments.
So I guess the one motion, and at least the only thing I have a proposed order for has to do with waiving guardian ad litem fee for the mother, I believe. Yes.
Yeah, this is an odd situation. The parties did file motions back in the fall. My understanding in reviewing the court file is it looks like there was a hearing for temporary orders in November 30th. At that time, Judge Warning said he needed additional information before he could enter parenting plan or financial orders. The parties were back before the court on April 10th. And at that point, the clerk's notes indicate that the court asked both parties to file updated parenting plans, declarations, and financials. No attorneys were involved at that time period. When I was retained by Ms. Dooley, I read that and tried to follow that order of the court. And the parties had attempted to do so on their own prior to Ms. Dooley hiring me. So we would ask the court to enter a temporary parenting plan and child support. And then also if the court would address my client's motion from March to waive her GAL fee. And Miss Corey is the GAL.
Well, based on them, let me address that issue. That's probably the easy issue. I think based on the declaration that was filed March 22nd, based on receipt of certain public assistance benefits, that she would be entitled to a waiver of that fee.
Thank you.
So that would be it. Ms. Corey, so that fee for the mother at least would be a state or public expense.
And I can update the court. My client has paid, I believe, his obligation in full.
Okay. Okay, so sign that order. And I know this has been heard. It was heard by Warning early in last fall. And it looks like there was something done by Judge Evans in April.
Correct.
So again, I was trying to determine what exactly there were proposed parenting plans filed. There were some proposed worksheets filed. I have a wage stub from him. And I believe I had wage stubs from her.
Yes.
And I guess my question at this point, is the state of Washington involved in the sense of any child support issues? Or have they been given notice?
I believe that our office has given them notice, but I would have to double check that with my legal assistant.
As they are original pro se litigants, I'd be surprised if they hadn't already entered their notice of appearance. If they did have an interest, they typically do that on their own accord for the pro se docket. But I haven't directly confirmed. I just assumed as well.
Yeah, and I don't see anything from them in the files. So, well, at this juncture, I mean, some sort of support seems appropriate. The problem I guess I'm concerned about is I really don't have any idea where we're at as far as the custodial issues. I know Ms. Corey was appointed. I didn't see in that order any dates for reports. Maybe I missed those. Ms. Corey, can you tell us where you're at on this case?
That's another one that is almost wrapped up, but I do have 2 that are due in the next couple weeks. So I would say maybe 3 weeks out.
I think and again, I'm kind of leaning back on what was previously done would be to simply set all those issues out until we at least have a report, at which point I can make a preliminary, obviously a temporary who's primary, and that's not necessarily a final decision. Those are temporary decisions, obviously. And then do a child support calculation. I don't have any problem backdating the support calculation if we need to do that.
Well, that was my difficulty too, even in preparing argument for my client is long distance transportation expenses are going to be heavily considered, obviously, depending on how the court rules, either visitation with my client or primary parent. I know that my client's anxious to have any visitation he can in Arizona. I don't know if the court has reviewed our materials and is willing to make some sort of interim order allowing my client to have visitation in Arizona. I don't think there's any safety concerns. And my client's mother was willing to facilitate that transfer. So if the court would be willing to give some sort of interim visitation, it's been a while that this case has been pending with no real movement. And so we would ask for some relief on the interim.
I know that my client would object to the kids going to Arizona for visitation. Mr. Dooley moved back to Arizona in February. He's been here and had visits in March, and he also had visits in June. My client is agreeable to him visiting when he's here, but would object to visits in Arizona. She does have safety concerns, which she detailed in her declaration. And so maybe it would make the most sense to just set this out a month so we can have the input from the GAL and get all of the temporary orders entered together.
Well, it seems that I certainly don't have any problem with him visiting here. I guess I need to have more information about some of the allegations that are being raised for that there's no allegations raised against the grandparent as far as transporting or anything like that, but there are some issues that have been raised. I don't know what, obviously they've been contested, so I'm not making any decisions about that. And I just don't have really any basis to make a determination about the existence or non-existence or the degree of what those might be. But it seems to me if he comes up, if they can afford to have his mom fly up and back, then he certainly can afford to fly up and back to visit between now and the next hearing.
Understood, and I can coordinate that with Ms. Powers. So do we want to set it out actually 4 weeks or?
Well, Ms. Corey, Can you give me a pretty solid day when you'd be able to have something for the parties? Because I'd want to set this at least a week after that, so they have an opportunity to see it and discuss it.
I can have that in by the 23rd.
Okay. You want to try for either the 30th or the 6th for a review then?
I'm available for either one.
Me as well.
Me too.
Do you have a preference?
Sooner rather than later. Actually, the 30th works.
Let's go with the 30th then at 1 o'clock, and we'll review it. At that time, we'll address some sort of temporary parenting plan, maybe not a full one, but at least we'll get some sort of temporary orders put together and address child support.
Thank
I
you.
don't need, sorry, just to clarify, I don't need to bring any additional motions. We're going to go off of those November requests.
I think, yeah, they're sort of pending. It doesn't make sense to spend a lot more money to file a bunch more paperwork when we really have just a couple of issues.
That's what I was hoping for as well. Okay, perfect. Thank you.
Okay, you're welcome. All right, so over to the 30th at 1 o'clock.
Thank you.
You're welcome.
Thank you.
And with that, we will end the session.